A point of order, John.
Apologize.
Well, I'm
taking
seeking
the call.
a call. Are you taking
the call?
Not a point of order. Sorry?
Seeking the call, Mr. Chair. Mr. Chair.
No,
Mr. Chair.
Well, I will take the call. Order. I'm taking the call from the Honourable John Boscawen. Proceed.
Thank you, Mr. Chair. And let me just comment on what Marion Street had to say. She summarised the basis of the ACT Party's, or one of the bases of the ACT Party's objection to this bill, sir, because we do believe that the iwi and hapu should have access to courts, and we don't believe the law should be codified, or certainly codified in the way that it has been. And so this denies the right of iwi and hapu to go to court and to fight for their common law rights. So this is a debate on part 3 of the bill, and in particular I will be focusing on the sections relating to customary title, the ones identified by the Honourable Krista Finlayson, sections 60, 61 and 64. But I also want to refer also to Mana Toka Ihu. But before I do that, Mr. Speaker, I do feel as I need to respond to some of the comments that Honi Harawira made earlier this afternoon. And, sir, I had hoped to have made this contribution during the debate on the last part before the vote was taken, but I was prevented from doing that. But the points I want to make, sir, are just as relevant. And, sir, the ACT Party totally agrees with Honi Harawira that this bill needs to be opposed and opposed at every step, sir, and we'll be fighting to the bitter end. But, sir, one of the points we wanted to make is that what Honi said this afternoon was this was a confiscation of Maori rights. A confiscation of Maori rights, and I think Honi and some of his supporters are of the view that iwi and hapu actually have customary title, have ownership of the entire seabed and foreshore out to the end of the territorial sea, out to the extent of the 12-mile limit, sir. And I think it's important, sir, to come back to the decision in the Ngāti Apa case. And once again, the Attorney-General quoted that this afternoon. Because the view that Maori own the seabed and foreshore, it is a common view amongst some Maori, sir, and it's interesting that we have a hikoi marching to Wellington as we speak, Mr. Chair. But I would like to suggest, Mr. Chair, that the reason the hikoi has been formed and is marching on this occasion is a lot different from what it was in 2004. In 2004, the hikoi was marching for access to the courts, acting for access, sir, to the courts and for justice. And so my colleague, the Honourable Rodney Hyde, joined that hikoi when it arrived in Wellington. But, sir, let me just comment on some of the observations made by Dame Sian Elias, the Chief Justice, and she said in the Ngāti Apa case, this appeal deals only with the initial question of whether the Maori Land Court can enter into the substantive inquiry. This only deals with the initial question, only deals, is this an issue that can legally go before the Maori court? It doesn't actually deal with the issue of whether iwi and hapu have customary title or not. She goes on to say, Mr. Chair, the significance of the determinations this court is asked to make should not be exaggerated. The outcome of the appeal cannot establish there is Maori customary land below the high watermark. So there you have it, Mr. Speaker. She says the outcome of the Ngāti Apa case cannot be exaggerated. It doesn't establish that there is Maori customary land below the high watermark. And so ever since that judgment, despite her observations that it doesn't determine that there's Maori customary land, there have been a group of New Zealanders who have believed that that is the case, that Maori own the seabed and foreshore. And what we've seen, sir, in this case is we've seen the National Party take fright, as did the Labour Party take fright in 2004 with the passing of the Seabed and Foreshore Act. And what both National and Labour have done is they have sought to restrict the rights of iwi and hapu to go to court to claim their customary title, I guess under a belief that they would win large amounts of New Zealand. And so what they've done is they've set, sir, in this particular case, they have set a codification, a series of tests, which the Attorney-General says will lead to certainty and equity. And what I want to explain in my call, Mr. Chair, is why it would do exactly the opposite, why it won't lead to certainty and why it won't lead to equity. Interestingly, that the Sean Elias goes on to say, nor will the appeal resolve questions of the nature of any property in land, whether it approximates a free simple interest or whether it's lesser property. Mr Chair, I want to focus most of my remaining time on the issue of customary title, but before doing so, I do actually want to comment very briefly, Mr Chair,
Honourable John Boscawen.
on the concept of mana tuku iho. And essentially what that does, Mr Chair, is that creates a universal right of consultation. And as Peter Sharples and Tariana Turia wrote in the New Zealand Herald last week, they said the new bill acknowledges that all coastal iwi have connections to the coast. Their mana tuku iho inherent authority entitles them to protect their waihi tapu and to be consulted on conservation and resource management issues. And so one of the reasons that this bill is a racist bill, sir, is that is a right that is only given to coastal iwi. What about other people living on the coast who are not iwi? What about non-Maori New Zealanders, Mr Chair, who also live on the coast, whose families have lived on the coast for over 100 years, who don't have the same rights as provided for in this bill, sir? And if that is not a racist provision in this bill, sir, I don't know what is. Mr Speaker, the issue comes to the tests of marine title and the rights that derive from that. And so the National Party has perpetuated the myth, the fiction, that the only very small areas of New Zealand will be open up to claims of customary title. They have said, for example, in their publications, that the test for customary title requires continuous exclusive use and occupation of an area since 1840. As you can imagine, this is not an easy test to meet. Well, sir, it's not an easy test to meet, but it's not actually the test. You don't actually have to prove continuous and exclusive occupation. You have to prove exclusive and continuous occupation without substantial interruption. And so what is the effect of that proviso? We don't know. Christopher Finlayson doesn't know, and so the appeal court doesn't know. And to suggest that this is going to lead to certainty is a load of hog's rubbish, Mr Speaker. If I look at the supplementary order paper the Minister has introduced, the provision, sir, in clause 61, the Minister is amending on page 22 of his SOP, clause 61, which provides that the use at any time by persons who are not members of an applicant group of a specified area of the common marine and coastal area for fishing or navigation does not of itself preclude the applicant group from establishing the existence of customary marine title. So, sir, you can make a claim for customary title, you can say you've had it exclusively, but the fact that other people come and fish in there, the fact that other people come and boat and navigate through there, that doesn't preclude you from making a claim, sir. It doesn't preclude the court from awarding you customary title, sir, and it doesn't preclude the government from entering into an agreement, sir, to grant customary title, sir. And so, sir, to perpetuate the fiction, the myth, and to mislead New Zealanders that the right to apply for customary title will only apply to a very small part of New Zealanders, so more small part of New Zealand, I think is deceptive in the extreme. I think the National Party are relying on the fact that New Zealanders are not taking an interest in this issue, Mr Chair, but I think in time they will, and they will take an interest in ever bigger and bigger numbers, Mr Chair. So let me turn to clause 64 of the bill, the benefits that flow from being granted customary marine title. Well, so the first thing you know is that with a grant of customary marine title comes the ownership of minerals other than those deemed to be owned under the Crown Minerals Act by the Crown. So basically all minerals and resources, Mr Chair, other than oil, gold, silver and natural resources. And so that right is granted, specifically provided in this bill, out to the 12-mile limit, out to the limits of the territorial sea. Well, sir, in 1840, the limit of the territorial sea recognised was 3 miles. And so what we're doing here, sir, we're setting ourselves up to transfer ownership of resources, sir, from all New Zealanders to a small select group of iwi, sir, who can meet these tests, sir. And the government suggests that's equity. How does that protect the rights of all New Zealanders, Mr Chair? Let me go on, Mr Chair. You also have the right to protect waihi tapu. And so I'd be the first to recognise Maori custom. I'd be the first to recognise sacred areas. But what New Zealanders probably don't appreciate, Mr Chair, is that when you lodge a claim for customary title, you can actually designate areas waihi tapu, that designates them sacred, and that gives you the right, if customary title is subsequently granted, to say, that's a sacred area, I don't want other New Zealanders to enter. Mr Chair, Mr Chair, Mr Chair,
Kelvin,
Mr Chair.
look, there's no need to yell.